Hello guys, welcome back to our channel AJAY SHARMA LAW. So in today's video I'm going to discuss section 19 of Hindu Adoptions and the Maintenance Act 1956, which deals with the maintenance of widowed daughter-in-law. So in previous lectures I will cover 18 section of this act, Hindu Adoption and Maintenance Act. You can go out through the playlist of this act, Hindu Adoption and Maintenance Act, on my channel AJAY SHARMA LAW. Section 19 of Hindu Adoption and Maintenance Act, maintenance of widowed daughter-in-law. When a woman loses her husband, it becomes very difficult for her to survive, especially if she has no income or property. The law provides the protection to such widowed daughter-in-law by giving them to the right to the maintenance under section 19. Let's read out through the bare act. Maintenance of a widowed daughter-in-law, a Hindu wife, whether married before or after the commencement of this act, shall be entitled to be maintained after the death of her husband by her father-in-law. So right out to the maintenance, a Hindu wife, whether she got married before or after this law came into force, has the right to be maintained by her father-in-law after her husband's death. The right is available only when she cannot maintain herself. For example, if she has no income, no property and no one else to support her, then the father-in-law is responsible to maintain her, provided and to the extent that she is unable to maintain herself out of her own earnings or other property, or where she has no property of her own, is unable to obtain maintenance. A. From the estate of her husband or her father or mother, or from her son or daughter, if any, or his or her estate. The widowed daughter-in-law can claim maintenance only if she cannot maintain herself from her own earning or property. She cannot get maintenance from her husband property like land, money or assets. Second, her own parents like a father or mother. And third, her children or from her children's property. So basically the father-in-law responsibility comes only when no one else and no property is there to support her. So is there any limitation on father-in-law responsibility? Any obligation under subsection 1 shall not be enforceable if the father-in-law has not the means to do so from any co-partnership property in his possession out of which the daughter-in-law has not obtained any share, and any such obligation shall cease on the remarriage of the daughter-in-law. So the father-in-law duties is only if he has the means to support her. This maintenance can come only from co-partnership property in his possession, in which the widowed daughter-in-law has not already received a share. If he does not have such property, then he cannot be forced by law to give maintenance. Let's talk about the limitations on father-in-law responsibility. Basically, if the widowed daughter-in-law remarries, then the father-in-law obligations to maintain her completely ends, and because after remarriage her new husband is responsible to maintain her. So basically a widowed daughter-in-law has a right to maintenance from her father-in-law, but only if she cannot support herself and no one else can maintain her. The father-in-law must have co-partnership property and the responsibility ends when she remarries. That's all about the section 19 of Hindu Adoption and Maintenance Act. If you found this video really helpful, so don't forget to like, subscribe and press the bell icon for more legal updates. Okay, bye bye guys, see you in the next video.